Hello and welcome to Assemblies of the World with me, Anna Isabel, and I have a big grin on my face, and that's because I have Mark Horn with me today, who is going to tell us about some very good developments that have been happening in the court cases that he's been working on. So welcome, Mark.
Thanks, Anna. Nice to be here again, and it's been a wee while. And yeah,
The nice thing is that every time I see you, you seem to be smiling more. So
oh, it is
it's
because basically they give themselves the rope to hang themselves, and more is being exposed. And finally, this is the High Court, so that people can see that there's lots of nonsense still going on, even at the High Court level, not only at the magistrates' courts.
great.
So off to the Court of Appeal.
After the Court of Appeal. Before we start talking about the Court of Appeal,
Yeah.
what's this about perfected court orders? Because
Oh, I'll cover all of that. It's
yes, because I think there's lots of people who will want to hear about this.
Yeah, when I get down to that point, just make sure you butt in, okay? Because you know what I'm like, I could talk all day about this stuff.
Yes. So where would you like to begin?
Yeah, basically the fundamental principles of the rule of law and the open justice principles, and it's undermining because justice is being done in our names. So, like people who've seen on our YouTube channel, we've put in an application for permission to appeal the order from Judge Dame Hill, who refused judicial review of the decisions made by District Judge Healy in the Magistrates Court. And 2 hours ago, I've just had confirmation the Court of Appeal have accepted our application for permission to appeal, which is the first step to getting the appeal.
So this is in reference to, so this judicial review that you're trying to
Yes.
push for
Yeah.
is to do with,
Basically, it's about the profound public and constitutional issues. So it's very, very fundamental. And basically, where we finished off last time was there was refusal on papers by Judge Ockleton on 4 grounds. The first ground was that peacekeepers have no standing in my personal tax matters. And the second was that the claim was out of time. We won both of these arguments in the court. And so Judge Dame Hill only had 2 issues really left to decide. The first one was alternative remedy by way of a valuation tribunal. Now, here Judge Dame Hill actually allowed them to put in without notice of an application, which basically meant we had to deal with this on the spot. And that was that there was an alternative remedy available by way of a section, what's called 111, subsection 6. If they refuse to state a case for the opinion of the High Court, i.e. if they do not prepare it, that we need to go to the High Court to get, to force them or compel them, as it's called, to get District Judge Healy compel him to prepare this case so that I didn't need to do it myself. However, we because this was an application without notice, I simply turned around to her and said, sorry, I can't answer this now. You're going to have to accept submissions because they've just thrown this on us. And so over the next morning, then I sent her submissions to show that she was wrong, or they were wrong with this argument. And therefore, she also ruled with us that we were correct, that that was not an option of alternative remedy. But we also won the original ground, that the valuation tribunal has no jurisdiction to deal with matters other than if a dwelling is a chargeable dwelling, which is Section 1 of the Local Government Finance Act, and who is the liable person, that's Section 6 of the Local Government Finance Act, or if there's a calculation error in the demand. Now, this is a significant success, and people all are saying that, you know, only Mark can turn an absolute failure into a success. But that's why I smile, because what this has done is, combined with Judge Dame Hill's reasoning for ground 7, so long as you don't argue whether your dwelling is a chargeable dwelling or whether you're the liable person or there's a calculation error, this means now the magistrate's court has to listen and provide you a reasoned judgment to the constitutional arguments.
So,
which is massive.
are we talking about charges being put onto people's properties? Is that what we're talking about?
The first step is the liability order in the magistrate's court. And this is where we've been trying to drive the argument into, because that's the cause of all council tax enforcement. So now with this judgment, they have to deal with these questions in the magistrate's court, which means we're putting it into the magistrate's conscience now. And basically, if they don't deal with it, then the order is void immediately. And with ground 7 being refused, you sit there and you wait until they give you a reasoned judgment. That's your right. And you sit, and if they call security on it, you show them the peacekeeper judgment ground 7, and you say, I'm sitting here until I get a reasoned judgment. Let them call the police. I'm sitting here. Have a look. This is what the High Court has said. I'm entitled to a reasoned judgment. I do not leave until I've got a reasoned judgment. So it's massive. So basically, that just really left ground 4 for your refusal, which was basically, as Judge Ockleton put it, perceptible merit. There is no perceptible merit in his eyes. So that there really is the foundation of this.
So take us back to the process of the liability order, because are we saying, okay, so there's issues with the way that the liability order is being presented. We know that.
Right. Yeah.
There's evidence of all sorts of fraud. We know that. And I think
it's not fraud. It's basically, they are only fulfilling a part of their oath, the statutory part, and thereby breaching their oath to the common law, which is that's the real problem.
So they're not following the
Due process of law.
Yeah, they're not following the rules, basically. And because they're not following the rules.
Absolutely.
So this is where you started this, is you started picking them up on the fact that, hey, you're not following the rules when it comes to liability orders.
Yeah.
And then that leads down to other avenues, to the point where you then are saying, okay, we actually need a judicial review, because the whole process is the way it's going, it's broken.
The way they implementing it is in breach of their duties to us, the public.
Exactly. So then it was a case of, actually, we don't particularly want you to have a judicial review.
Correct.
And coming up with reasons as to why you shouldn't have the judicial review.
Correct.
And what you've just described is the grounds on which those were denied, and the grounds which you have managed to begin to overturn, to the point where you're now being allowed a hearing. That's
we've applied to permission to the appeal court now, because Judge Dame Hill, when I go through the grounds, basically she's changed the questions that we asked, answered different questions, ignored facts, all sorts of shenanigans. And so in the appeal, we've actually added 2 more grounds in addition to the 8 grounds that she refused. The first one is about the legal profession's failure to their duties to the rule of court and their duties to the court, which includes putting the court with all relevant law within their knowledge. And these duties stand above the duty to simply win a case for their clients. It's a massive money-making machine, whereby the one legal professional will not call out another legal professional, which I've said all along, this can only be done with litigants in person who's licensed to practice this monopoly. We don't have a license to practice, so we're not at risk of losing it. Therefore, we have no conflict of interest. So one of the additional grounds for the judicial review is the legal professional's behaviour, specifically Liverpool City Council's counsel, Simon Whitfield. And basically, we're calling him out in the appeal court for failing in the duty to the rule of law and his duty to the court. And basically, these are both legislatively, this is all legislatively, i.e. in statute law. Even Parliament has told them this is your job. And that's regulated through this monopoly of the public entrusting them is in the Legal Services Act 2007. That then in turn takes us to the relevant codes of conduct, which are meant to be upheld by the Solicitors Regulatory Authority and the Bar Standards Board. They have handbooks which affirm the primary duty of all legal professionals is first to uphold the rule of law, then to make sure that they fulfill their duties to the court, which means putting the court with all relevant law in their knowledge. That means they need to give an opinion of all the law that we present to the court. If they ignore our law, they are in breach of their professional duties.
So let me get this straight as to what this means in practice. So in practice, you present a case which is correct in law.
Correct.
If the counsel for the other side sees that it is correct in law, are you saying that it's their duty to advise their client that it's correct?
Exactly. They hold their hands up.
Happening?
Absolutely. Okay. Absolutely. So an example of this in this particular case is Simon Whitfield, the counsel for Liverpool City Council, was aware in the underlying case in the Magistrates Court, we were relying on the 1704 House of Lords authority, which overturned the 1703 majority decision in Ashby versus White. So he knew about it in the Magistrates Court. In our submissions, he ignored it. He failed to bring it up in the court. I brought it up in the court. He failed to address it in the court. I brought it up in the judicial review. 3 times in written submissions, he failed to address it. In the court on the day itself, 4 times at least, I brought this to the attention of the court, including reading the 2 critical passages that Parliament cannot, by their votes, amend the common law, and they cannot interfere with private property rights. Yet, despite, in his case, 11 times this being brought to his knowledge, he ignored it. And equally, Judge Dame Hill ignored it on at least 7 occasions. But even worse, she ignored it in what's called corrections. We had a draft judgment, and again I pointed it out, and both Simon Whitfield and Judge Dame Hill ignored it. And she's answered a different question.
So what they're doing is, in effect, cherry-picking the bits of the law that suit them.
Correct.
Okay, and they are ignoring law which is real also and which would go against their case.
Absolutely.
Okay, so this is how it's operating, which is why you are now adding this as an additional.
Correct. Yes.
To your wish to appeal.
Yeah.
Okay, well.
So basically, just one example of the impact of this is they claimed, Liverpool City Council claimed £5,412 in costs. And I put in based upon their conduct, their failure to address authorities, and specifically the failure to address the House of Lords appeal, and that being a breach of their professional standards and their duties to us, the public, Liverpool actually withdrew their application for £5,412, which, guess what? Now the council taxpayer in Liverpool is going to have to foot the bill for the unprofessional behaviour of Roger Mann, who's a 24-year practicing solicitor, and Simon Whitfield, who's been on the bar since 2009. So they've withdrawn their cost claim for the hearing of £5,412. Welcome, Liverpool taxpayer. That's getting added on your bill now.
So although you no longer have to pay it because they know that you were correct, they are still.
Well, they didn't admit it. They just withdrew it. So I couldn't pursue it.
No, that's right. So, but meanwhile, their, I'm going to say it, failing solicitors are still getting paid.
Yeah.
And it's, of course, coming out of their the council's expenses, which are footed by the lovely general public paying council tax.
Correct.
Okay.
Yeah.
All
and
right.
Basically, the whole legal profession is about a £60 billion money-making machine. And this is the way they behave.
You must be incredibly popular in those circles just at the moment.
Well, it gets even better, Anna. It gets even better because we're calling out Judge Dame Hill for her conduct and failure to provide a reasoned judgment.
Yes, because I think it's bad enough when you have the legal advisors ignoring points of law, but when you actually have a judge also neatly sidestepping, and that's a very disconcerting turn of.
Oh yes, and in this case you can see in many places she's actually applied her mind to avoid answering the question. So basically, I mean, the reason for a good judgment, really, it's not just a formality, it's absolute vital safeguard against arbitrary decisions. It's about transparency, it's about accountability. When they deviate from, and there's a pretty much standard format, it risks leading to predetermined outcomes rather than independent, objective decisions. Now, remember, not only is the judiciary independent, each judge within the judiciary is independent, and they are independent to the rule of law. And the rule of law is a set of rules, how you resolve a dispute, how you apply logic and reason to the evidence before you. So we've got omissions, all sorts of things where she's failed to accurately summarize issues, i.e. she intentionally, specifically in the constitutional argument, intentionally and knowingly answered a different question to what the issue was. She failed to properly set out the legal framework. She failed to analyze the legal framework, and that's critical so that you can determine what is the relevant test against which you're testing the evidence. So without that, and that's the way that you manage to basically misinterpret the questions and answer different questions to what were asked. So we're calling her out for this. And this really is, well below the standard that anybody should expect. In the magistrates' courts, yeah, maybe. Even there, it should never happen because nobody should be a judge if they don't understand the basic constitutional principles, if they don't understand their job. So it's very serious, this. And one example was in regards to the summons, was it the summons or the reasoned judgment? I'll come on to that. basically she said, oh no, the perfected liability order. She said, oh no, the system is fair. And then she said, oh no, in Mark's case, it was added fairness because he got a written judgment with a judge's name on there. So hang on, either it's fair or it's not fair. It's not a variable dimmer switch subjective to a judge's opinion. This is the way that they can manipulate judgments. And if people don't read and don't understand the substance behind it, they come to all sorts of false conclusions. So she marked our case as unarguable on all 8 grounds. And she even certified 6 of those 8 grounds as totally without merit. However, the 6 that she argued were totally without merit, she hasn't even answered the question we asked. So she'd answered different questions, which I agree with some of them, yes. If that was the question I was asking, I agree with you, we're totally without merit. It's insane.
So essentially, what you're demonstrating here is that there is a procedure, a process that judges need to follow to demonstrate and, I guess, justify their judgments.
Absolutely.
In order to prevent them from being arbitrary or biased or prejudiced.
Absolutely.
There needs to be a process of demonstrating, and your argument is she's failed to actually do that.
And we're calling her out as a ground of appeal for her not doing her job either as a High Court judge. And we've got plenty of examples of this. And so basically it all comes around what's called open justice. Remember, justice is being done in your and my name. Now, her judgment is the public record, which should reflect what actually went on. That means, what were my arguments? What were Liverpool City Council's counter-arguments? What does the law say? What do I need to determine and test the arguments, the facts against in law? And that's how I reach my conclusion, my decision. So this is actually a public record. And by not addressing and giving the full public record, that is actually tampering with public records. By omitting stuff intentionally, and there's very strong evidence. I mean, with the Ashby versus White House of Lords appeal, it was brought to her attention, and I can show you, in at least 8 places. So either she's got a very short memory, even from the day before she handed the judgment down, was the last time it was put into her memory, and she still chose to ignore it and answer a different question. That there, to any reasonable observer, is willingly and knowingly acting. That cannot be a mistake.
It be argued, oh, this is a very ancient law, and therefore, you know, it's no longer valid.
Again, that is actually answered in the judgment we relied upon, because what precedent actually is, and it's in that judgment, it's logic and reason applied to facts. So if you've got the right formula to resolve the dispute 100 years ago, 1,000 years ago, it makes no difference. Or 10 years ago. As new situations arise, you look for similar formula, which will give you a fair and just outcome. That's the test that you apply. That's the law that you apply to the evidence. If you can't find any existing law, and again, it's, I think in the 1765 Antic versus Carrington, if it is law, it will be found in our books. If not, it isn't law. So if you come to a novel situation, something new, yes, you may need to create a new formula to resolve a novel dispute. So it's very, very simple. There's nothing complicated about law at all.
So you actually started to talk about the perfected court orders.
Yeah.
Okay, I think we need to know what they are and what the situation is.
Can I just go through this systematically? Okay,
Yes.
that there's ground 8, and we can spend some time. Oh, was it ground 8 or 7? Okay, but we'll get to there. I just quickly want to cover some other important aspects, grounds 2, 3, 4, 5, and 6. Okay, because to show how each of those, where she found no rationality and certified our arguments as unarguable, you'll actually see the reasons are varied. So if we start with ground 2, this was about the CVP links and about public access to the court. There were 13 empty seats. So like I said, justice is being done in our name. And in her judgment, she totally ignored the law relating to open justice. She merely referred to secondary legislation and guidance and totally avoided answering the question, and she applied the wrong test. The test for open justice, it's a constitutional right, open justice, is strict necessity, a very, very high bar. However, because she did not analyze the law on it, it was in our submissions, she ignored our submissions and instead decided to use the lower threshold of irrationality. So by changing the goalpost, she tested District Judge Healy's excuse of the courts being exceptionally busy or it being impracticable, i.e. nothing was set up. She tested that against irrationality, and even there, she acted, I mean, it was irrational. There were empty seats in the court. One of the duties of District Judge Healy was not to say the public gallery is full. I asked him, but there's 13 empty seats here. He then must provide a reasoned judgment as to why those 13 seats can't be used by the public. Nobody else is using them. It's not a health and safety issue. And she simply put this down, it's within his judicial discretion as a case management decision. However, the correct test of strict necessity is, well, of course you guys can sit down in those seats. And if somebody from the press comes in, one of you will have to give up your seat. Or if another court officer comes in who needs a seat, one of you needs to give it up. So that's an example of the direct application of strict necessity versus irrationality, and how she's manipulated the outcome by failing to explain to a reader of the judgment, what is the open justice principle? What is the test against which I need to hold District Judge Healy to account? Did he do his job properly, yes or no? So she's only taken the lower test, the easier test, and the way she's done it was not to put in the relevant law, because any reader would see for themselves that the conclusion she reached was wrong. So that's an example of how they manipulate these things. But there's a format of how to do this. So similarly with the recording, which was ground 3, I was very clear that it was for personal use, because I've been in enough council tax hearings that without a record, it's very difficult to appeal anything. Now, all she did was said, well, in accordance with the Contempt of Court Act 1981, Section 9, and provided some other guidance and stuff like that, one of which actually said, must have regard to the open justice principle. Never discussed the open justice principle here either. Again, the test, nobody knows because she's not mentioned it. And so, again, she did it with rationality, the lower bar. And District Judge Healy's excuse was, oh, you can have a note taker. Who on earth can make an accurate record? Because we all know the magistrates' courts do not record. There is no transcript available. And there's no way a note taker can fulfill the same job. It's totally disproportionate what he offered. And that does not meet the high threshold of necessity. And then even worse, afterwards in his certificate of refusal, because he realized that he's got a bit of a problem here, he made further excuses. Okay, you can't do that. With your reasoned judgment, you have to explain yourself. You can't come and fix the problem afterwards. That's an admission of not having made a reasoned judgment in the first place. So basically, that there shows you very quickly on those three grounds how really you have to read the judgment. And if the facts and the law are not presented accurately, then how can anybody understand the conclusion? How can anybody actually know that that's not what was said in court? Okay, so those are the first three grounds, and then it starts to get into the specifics really of council tax. Okay, so the first one, ground 4, was demand notice versus bill. So basically, what she turned around and said, oh, well, the regulations don't prohibit the use of the word bill. What she's done there, again, because she's not explained the legality test, which we'd argued, she's inverted the legality test, sorry. So she's turned upside down what was asked. So it's not up to me, okay, to prove that they don't have authority. It's up to them to prove they have authority. They cannot do what they're not specifically authorized to do. They can only do what they're told. It's just like at work. You need to do what your boss tells you. And so what she said is, oh, well, the boss didn't tell me I can't do it, so that's why I took the day off. I mean, this is the insanity of it. Okay? Honestly, it's just absolutely irrational. But again, because she didn't analyze and put the public with the knowledge who read these judgments, how can they make a judgment if the judgment's good or bad? So that there is misleading. That there is effectively manipulating the public record. She's not put our arguments in there. She's not addressed the law which is relevant for the test, and she's just made something up that she wants. So that there is sort of what happened with ground 4, and we're saying this is totally wrong. Statutory interpretation is quite clear. She's not set out the law regarding statutory interpretation. There's specific case law precedent that the court cannot make up fanciful words where Parliament has been clear. Parliament uses the word demand notice, council tax demand notice. It doesn't use the word council tax bill. So that our question was, where is the authority in accordance with Entick versus Carrington 1765? Show me. If it is law, it's in the books. So show me from the books where you can change the word demand notice to the word bill.
Why is this important, this difference in words?
This one's particularly significant because they cannot chase a payment until they've served a demand notice. It's the demand notice which authorizes chasing payment.
So a bill is what then? So clearly these
basically, excuse my French, a council tax bill is toilet paper in law.
Right.
Nothing more than that.
Okay. Right. I just want to come back to the two words, bill and demand.
Mm.
Why? So we understand that it should be a demand.
It is a
They
demand.
have two. Do they have two different legal meanings, demand and bill?
Well, basically, one way to look at it is spoiled brat kids demand. They have no reason, they just simply demand. Whereas a bill, generally, the understanding is there's some underlying negotiations. I can check if a bill is right and I can negotiate. So bill is used really in a commercial sense. And when you understand that statute law is not law, what it actually is for council tax, ULEZ, speeding fines, etc., because there's no harmed party, it's merely a statutory demand in law. That's all it is. It's a statutory demand.
So this is why you then say that the council tax demand is not worth the paper that it's written on.
No, the council tax bill is not worth the paper it's written on.
Okay, all right, because it should be demand.
Yeah, but basically, the constitutional argument goes in, even if you call it a demand notice, in accordance with the statute, is it lawful for what Parliament did? Can they tax you, tax a person's right to life, which is a human right, by taxing their shelter from the environment?
Okay, so this
That's
is
a constitutional argument about the legality and lawfulness of council tax. If you
so talk us through, because you've used the word constitution a number of times, and a lot of people are going to get confused because we know that we don't actually have a constitution.
We absolutely have a constitution.
So
this is part of the brainwashing process.
Okay, so tell us about that.
I'll come on to that. We can finish on that. That's ground line, if that's okay.
Great.
Okay, the next one is ground 5, which is the delegation or lawfulness of the summons. Again, she did not address our arguments. She did not put forward to the reader the law. And basically, the law is a judicial decision cannot be delegated, and the authorizing the issuance of a summons is a judicial decision. And if Parliament changes the common law, it needs to be in your face. They can't do it through the back door. So in the Magistrates Court Act, Section 51, it clearly expresses in civil matters, it must be a justice of the peace. And in the regulations which are specific for council tax, they can't use anything other than the regulations to enforce council tax. It says a justice of the peace. So in order to try and delegate it the way that they've used through the Court Act 2003, without specifically drawing everybody's attention that they've changed Section 51 of the Magistrates Court Act, which is the general act for summonses, and specifically for council tax, not drawing the people's attention to the regulation which says justice of the peace or delegated person. So it's obvious to somebody it's been done through the back door. This is unlawful. Okay. However, she didn't again go through this. And she actually again used an inversion to deem our ground unlawful. Unarguable. She said, there's a list of things which cannot be delegated. Therefore, everything else can be delegated. So basically what she's saying is anybody employed can become a judge. It's a delegated thing, because it's not on the list of what cannot be delegated. That's the insanity of her decision. Totally irrational.
But we know that not anybody can become a judge.
But according to her logic and reason, anybody can become a judge if the Lord Chancellor authorizes them. I.e., you know, it's insane.
Perhaps you ought to apply on that basis.
Yeah.
We should all just start trying to become judges then on that.
Yeah. Okay. So just two more grounds before we get onto the perfected liability order and the constitutional stuff. So basically, ground 6 was that District Judge Healy basically abdicated his judicial duty to determine costs reasonably incurred for the summons and the hearing and the hearing costs. And what he did was, because they couldn't evidence how they reached their costs of £80 total, £56 and £24 for the hearing, he gave them 0. Yet both Roger Mann and Lindsay Nabbs from the council were in front of him. Everybody saw them. He even referred to them in his judgment. Therefore, it's clear the council did incur costs. His job was to determine what are reasonable costs. Instead, he just made them 0 and therefore failed in his duty to determine reasonable costs. In my submissions, which were in evidence before District Judge Healy, I detailed calculations showing generously reasonable costs are no more than £12.12. More realistically and more reasonable, because it's a fully automated system, it's no more than £4.98, call it £5. So based on the evidence before Judge Healy, he could not make it 0. He should have made it either £12.12 or £5 or thereabouts. That's his duty. However, had he done his duty correctly, this is probably £1 billion bonus for councils where they are stealing money from the most vulnerable in society, and the courts are allowing the councils to get away with this. Had he ruled, okay, £12.12, I determine reasonable, because based upon the evidence before me, Mark's given me these calculations and I had supporting quotations from companies, everything I had there. And that means instead of them charging £80, which in my hearing brought into Liverpool City Council £210,000, there were over 2,500 people in my bulk listing. Now, if that was reduced by a factor of 8, in effect, you're talking about £40,000 instead of £210,000 being taken from the poor. Okay, and this is happening all over the country, not just in Liverpool. So also what that would have done is shown other courts how you determine reasonableness. And that would have set a precedent. Okay. Now people will argue about the word precedent. Remember, precedent is logic and reason applied to evidence. So long as you take the same calculations, the same evidence before any council tax hearing, this should drive the costs down on the poor. Why are they being taken to court? They've got no money anyway. And then they still extort all of this extra money because the judges do not do their jobs. So this is actually a big thing. And the second aspect of this argument that we had was about Simon Whitfield's £950 that District Judge Healy felt was reasonably incurred. Because what they're doing is, if you're challenging council tax, they remove you from the bulk list and give you an individual hearing, and then they basically allowing councils to bring in unrealistic and disproportional legal representatives. And indirectly, what that's doing is threatening you with costs. And as a result of that, people are making economic decisions as opposed to standing on their rights. They submit for economic reasons. It's no different from beating somebody over the head.
Yeah, it is using, well, I mean, a long time ago, for a long time I've said, while we can't afford justice, there is no justice. You know,
Yeah,
because
and
can't
if
afford.
we've got time at the end, we can talk a bit more about that. Yeah.
Yeah.
So basically, ground seven was unreasonable, irrational judgment. Are the judgments rational, and do they cover all the key arguments? Like I've explained to you already here, this is one of the grounds against Judge Dame Hill. I've already explained to you, even in her judgment, okay, there's loads of unreasonableness. But basically, now we get onto the perfected liability order. Okay, essentially, it's simple. Again, people do not read this judgment because, again, this is the precedent. She's the first judge to admit, even though she doesn't realize it when she wrote the judgment, it is a physical document. Spoken in court and on the court record is not sufficient because she's admitted it needs to be extracted in writing in any format they want. So in 2003, the statutory format was removed. All they did was removed and said to judges, you do not need to make the liability order in Form A or Format B, i.e., it left up to judicial discretion the format. But that format, Judge Dame Hill has finally confirmed, so we have it in a judgment, is in writing, i.e. physical. And that's how it clears up the latent judgment and it clears up the COFA judgments. Without a physical liability order from the court, not from council records, there can be no council tax enforcement, full stop. That must include the judges' names and the legal advisor if it was a lay bench. You have every right under the open justice principle to know who's made a judgment against you. That's a basic right to the due process of law. So people have said, Mark, you're telling them how to enforce council tax. Absolutely. Okay. And the reason for this is because in the open justice case of Tracy and Norman, we've got from the circuit judge confirmation that if the legal advisor, the magistrates, or district judges or deputy district judges act in bad faith, then you can sue them. Therefore, we need their names, and therefore all we need to do is follow the process so that we can say, I told you, and you chose to ignore that. You were worth the knowledge, and that is bad faith, so now I'm going to sue you. So here's the constitutional argument. You've admitted you've got my submissions. Now give me a reasoned judgment. Am I right or am I wrong? Explain to me if I'm wrong, why I'm wrong. And if you don't do that, and you still grant a liability order against me, guess what? I'm going to sue you. And you tell them clearly in advance. So we'll be updating all the notices. And you're going to find very quickly that these magistrates and judges are not going to want to do this anymore. So we're shutting down the cause of the problem. The magistrates not doing their jobs and the lay magistrates being ill-advised by the legal advisors not doing their jobs, because guess what? Under the Courts Act, I can also sue the legal advisors. So by giving them your rebuttal, your reply to the complaint, confirming it's on the record, and giving it to them physically and being able to witness that, they have to answer your questions. And if they don't and still grant a liability order, you can sue them. And also remember, the magistrates are your neighbors, or meant to be. And they're going to get called out, and people are going to find out who the hell is starting this nonsense. So it's a strategy, okay? Yes, I'm telling them how to do their job. And the reason is we go into the magistrates' court, we start suing them, we start explaining to them, we start putting our constitutional arguments in there so that it plants seeds, so that they start to think, it goes into the consciousness, and then they start to question what they're doing. And especially if they're going to get sued, it's going to be a bit of a faster process. But obviously, they're going to put whatever they can in the path to this progressing. But it's a game of chess, one move at a time. So that really is the perfected order. And guess what? Without a judge's name on there of who made the decision, no other than the judgment of Judge Ockleton, who refused permission, it says quite clearly, if there is not a judge's name on there, that is a fatal flaw, as if the decision did not exist. So by them getting an extract, a certified extract of proceedings, that doesn't have the judge's name on. That's only a certificate of proceedings. That is not an order. So they're going to be forced to put the judge's names on them now. So that's the significance behind our failure on that ground, which she deemed totally without merit. And people are saying, you guys don't know what you're talking about. So it's about understanding, reading between the lines, reading it, and following logic and reason. So even though she tried to answer a different question, she intentionally tried to misdirect the reader of the judgment that we were arguing about a signature. We weren't. She answered the question about a signature. That wasn't the question we asked. We asked about the judges' names. So again, if you don't understand, and she inaccurately reflects the record, but give her dues, in one sentence under the title, the signature issue, she did say, we were asking about judges' names. And all the rest of it, she then just talks about signatures. So again, you've got to be very careful with this stuff when you read it. So finally, the only one left is Anna, is constitutional. Let me quickly tell people what happened here so they understand why her judgment is no different from the Sharon's judgment, the Clifford judgment. Because again, she ignored the evidence, like we said earlier. At least Simon Whitfield, on 11 occasions, he was with the knowledge it was not the 1703 Ashby case. It was the House of Lords appeal of that in 1704. So, and with Judge Dame Hill, this was at least brought out to her 8 times, including the day before she handed this judgment down. So she could have corrected this. Okay. So she knowingly misled the public with this one by saying that I was arguing that the Kofa judgment was valid. And I was relying on the 1703 case. She did not mention the 1704 appeal. Nobody who reads this judgment actually will ever know what was argued. And therefore, basically, because the 1703 judgment does not include an analysis of the 1704 judgment, okay? And the 1704 judgment is an appeal, is the equivalent of a Supreme Court judgment today. That was our Supreme Court then. She's relying on a High Court judgment and ignoring the Supreme Court judgment. Okay? So again, by misdirecting the fact or misrepresenting the facts of what was the question, she's answered a different question. I know that the Kofa judgment, if you want to argue the Kofa judgment, it's nonsense. You can't rely on the Kofa judgment. I know that. So why on earth would I be arguing the same thing which I know is irrelevant? I was saying it's irrelevant myself. So you can see with these examples how by changing the evidence of the reader, of facts, of law, you can answer whatever question you want and present whatever answer you want. And this is what open justice is about. The whole video analysis we've done is presented the evidence to the public in the open. We've shown them you can download all the case bundles. You can download the authorities bundles. You can download the judgment. It's all there. And when you put these pieces of the puzzle together, anybody can do what I've just talked about here. But it takes a lot of work and most people haven't got time. But the judges and the legal professionals are entrusted by us to do this properly. And I can tell you, when they start doing this properly, 90% of the legal profession will be on the dole, and that's where these people deserve to be. And with AI, this would not have been possible. We're doing our own AI, but one big danger with AI, you must check. It needs human input, okay, for a number of reasons. I would never have been able to get that appeal in if it wasn't for our AI model. And we really are advancing with that rapidly. So overall, looking forward to the House of Lords appeal, whether they, I mean, not House of Lords, the appeal court decision, whether to grant us permission or not. Because guess what? They have to commit in writing their reasoned judgment. And everybody can see what we've submitted. And therefore, everybody can see whether they're providing a reasoned judgment or not. So, yes, exciting days. So, when I originally started this journey, Brian came up with the idea of the no obligation challenge, because that's just the vehicle about that we wanted to bring in this and teach people about their rights, their constitutional rights, the job of Parliament, the job of the courts, and so forth. This, the very, very first notice I wrote, Dijon and I took it to a retired High Court judge and asked him the simple question, can you tell me, where's the obligation? Where can Parliament or anybody else tell me what to do? After a 3-hour discussion, he agreed he does not know where that comes from. 2 weeks later or 3 weeks later, Dijon did a bit of work for him. And he turned around to Dijon and says, you know what? I've thought a lot about what you guys said. I can't find an obligation, but you guys will not succeed. You are trying to turn over 300 years of the abuse of the due process of law. I'm not here for 300 years. This is changing, and it's changing so fast. And AI and computers and technology is what's allowing us to actually resolve this for once and for all. And there's an old Latin saying, Fiat, justitia, ruat, caelum. May the heavens fall, justice must be done. Why? Because the truth will always prevail. It's just a matter of time. So I'm incredibly optimistic, Anna. And now we'll see, because the other thing that he told us was, in the magistrates' court, you maybe got a 10% chance of getting justice. At the next level, the county court / crown court, 25%. High court, maybe 50%. Appeal court, maybe 75%. Supreme Court, over 90%. So as we go higher up the chain, the more likely we're going to get justice. And the problem is, it's very expensive.
Yes.
And hence, only the rich have access to the law. And that's what PeaceKeepers is about, to try and bring the law into the lower courts and teach people how to hold these people to account. That's what it's about. And people must remember, this is not a silver bullet. This is a game of chess. Okay? It's all a strategy. They know they're in checkmate. We know they're in checkmate. However, they're trying to put in as many obstacles as possible to avoid the inevitable. Because whether Mark does this or somebody else, it's just going to, if somebody else starts doing the same thing, then it'll just affect how long it takes to get the rule of law. And that's what it's all about. They can't stop it because they need technology for their control systems. And guess what? Everything in life is a mirror. If you needed to control, that's our freedom. We just need to transmute the energies, the negative into positive, to create the future that we want. I don't care about WEF or anybody else's opinion. I want the rule of law, and I want a free market capitalism. I want to see if that works. We've never tried it. Let's give it a go.
It's so true. We've never tried it because it's constantly being interfered with and manipulated. So
Correct.
we've never actually done it.
Sorry for so long, Anna. But...
No, that's okay. I just wanted to check with you this notion of constitution, because many people believe that we do not have one.
The Constitution, honestly.
So what is this?
The Constitution is simple. The rule of law, precedent. The highest unrebutted claim stands as truth, and to stand as truth, it's logic and reason explained to everybody to resolve a dispute. That is the Constitution.
So this is not
how simple it is.
So it's not a constitution in the sense that the Americans have a constitution. It is an understood, perhaps, I don't know if you would call it an agreement that exists on which everything is pivoting.
Basically, self-evident truths. It's self-evident, all are equal under the law, nobody is above the law. That was expressed in the US Constitution, or the Declaration of Freedom.
Yes.
All we're doing is 300 years later, manifesting it into the material. So the thought was expressed 300 years ago. We've had to work out, what does it mean we all equal under the law? At the time, these people had slaves, they had all sorts of stuff, and women couldn't vote and whatnot. It's taken us 300 years to fill in that detail. And now we're actually going to be manifesting it into the material. So with the Bill of Rights, it started with Magna Carta 1215. The significance of Magna Carta 1215 was the king subjected himself to the law. But that law was only the law between the king and the barons. Then in 1688, with the Bill of Rights, that was extended to Parliament instead of the barons. And all we're doing now is manifesting the Parliament being our representatives to do what we want. And therefore, that's the final manifestation of all are equal under the law, nobody's above the law, of 1,000 years of thought and action manifesting into reality now only, finally.
Well, it's been a long time coming.
Well, that's the fractal universe. That's the way it works.
So it's been a long time coming, and I want to thank you for the work that you and the Peacekeepers are doing in helping to make this happen, at least in this life for us.
Oh, this is less than 10 years, 5 years even. You
Good.
can see the system falling apart all over the show.
Well,
we even had, with the charging order, a judge turned around to a litigant in person and asked them, what does a charging order look like?
Oh, lovely.
Okay. Think about that. A judge asking a litigant in person, not a solicitor, a litigant in person.
Brilliant.
So the change is real. It's there. You're starting to see it everywhere. It's fantastic.
Brilliant. I thank you again for...
You're welcome. Thanks very, very much for having me. Honestly, it's lovely.
And I just want to now remind everyone that the Peacekeepers course is free. It's online, and the link is in the description box. If you already have done the Peacekeepers course and you would like to take it further to becoming a peace constable, do please make sure that you are a member of CABI and get in touch so that we can help you progress this further, and that you can also be a part of the wonderful new society that we are building together.
I used to have a website years ago called Be the Change You Want to See. Be the leading light.
Well,
give
there's
people reasons to follow what you're doing. You don't need to force them.
No. So there's an invitation, and all the relevant links are in the description box. Thank you all for watching, and until next time, goodbye.
Thanks, Annabelle. Thanks, everybody.